What does it mean when the defense lawyer yells out, "Objection! I'm not allowing the doctor to answer on the grounds of Carvalho"? What does that mean in a medical malpractice case in New York? You want to know the answer? Come join me on this walk on the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you brought a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. And now your doctor denies all of your allegations. During the course of your lawsuit, I will have an opportunity to question your doctor, the doctor whom you have sued, in a process known as a pretrial deposition. It's really a question and answer session that takes place typically in the attorney's office. However, during COVID times, we usually do it on a Zoom call. What we do is we have a court stenographer on the Zoom call, and that court stenographer is there to record all of my questions and all of the doctor's answers. The answers that the doctor gives represents his sworn testimony, and you should know, carries the same exact weight as if he is testifying at the time of trial in court in front of a jury. So now, during the course of questioning, I ask the doctor a particular question. The defense lawyer yells out, "Objection!" I'm not allowing the doctor to answer that question. I direct the doctor not to answer on the grounds of Carvalho. Now, what does that mean? First of all, you should know that the defense lawyer has a legal right and an obligation to go ahead and make objections if he believes that my question is inappropriate or improper. They have that right. And many of these attorneys actually exercise that right, some more than others. Now, one of the most common objections we see during these pretrial depositions are that I did not ask the question properly. Objection! That's an improperly phrased question. Re-ask it, counselor. Okay, so now I'll ask it a different way. Maybe I was inartful. Maybe I didn't ask it the way I should have asked it. So now I'll ask it a different way. And if I get another objection to form, which is please rephrase it, it's not phrased properly, I'll just ask it again. I can ask it 20 different ways. Let's say you sued 3 different doctors, and now you claim that each one of them caused and contributed to your injuries. Now, each one of those 3 doctors deny your allegations. During the course of pretrial questioning of doctor number 1, I asked him a question. I said, "Doctor, do you have an opinion with a reasonable degree of medical certainty as to whether doctor number 2's care and treatment of your patient, my client, was done within the standard of care?" And now his attorney jumps up and yells out, "Objection!" I direct the doctor not to answer that question on the grounds of Carvalho. And you know what I say? I say, "Counselor, I disagree. I believe the doctor has to answer that question." So now, first of all, what is Carvalho? Carvalho is the name of a lawsuit in where a court made a ruling that basically said, look, if you sue a number of different doctors, you can't use one doctor to point the finger at doctor number 2 or doctor number 3. You can't use any one of those doctors as an expert against the other physicians who are also named in this lawsuit. So basically what I'm trying to do by that question is, I want to know what this guy thinks. I want to know what he thinks about doctor number 2's treatment. I want to know what he thinks about doctor number 3's treatment. And the reason I want to go ahead and ask that type of question is because I want this doctor to criticize. I want to see if he'll criticize doctor number 2 or doctor number 3. In every single instance, the doctor's attorney is going to turn around and tell the doctor not to answer the question. Why? Because the law allows them to object to that question, and in that limited instance, to tell the doctor not to answer my question. The doctor is not there as a medical expert to give critique and comment about the care and treatment rendered by the other physicians in this lawsuit. That's what my own experts are for. And I certainly will do that. But it also helps to support our claim if I can get one or more of the doctors to point a finger at somebody else. I will tell you, in doing this now more than 32 years, it is the very, very rare instance where one doctor will point a finger at another doctor named in the lawsuit. So now let's get back to the objection. The objection is made by the attorney. The attorney goes ahead and says, I direct the doctor not to answer based on Carvalho, referring to this legal case and this specific legal ruling that says that the doctor is not to give expert testimony or opinion testimony about other doctors in the case. All right, but what about this scenario? Let's say I ask the doctor a question about his own care and treatment as to whether it was appropriate while he's treating the patient, and coincidentally, the patient is also being treated by one of the other physicians as well. If this doctor's answer somehow implicates the other doctor's care and treatment, does the defense lawyer have the ability to tell the doctor not to answer the question? In my opinion, the answer is absolutely not. The doctor is required to answer questions about his own care and treatment of my client, of his patient. And even if it implicates one of the other physicians involved in the case, in my opinion, the case law favors the doctor answering the question. The defense lawyer, on the other hand, is going to turn around and argue, no, any time that there's a possibility that the doctor's answer may implicate other people in this case, he should not be allowed to answer that question. And my feeling is that's not the correct ruling, that's not the correct interpretation of this particular law. So why do I share this with you? I share this with you because this comes up often in these medical malpractice cases where I have a chance to question the doctor whom you have sued, where you have sued more than one doctor in a particular lawsuit. And now I'm in the middle of questioning them during their pretrial deposition, and I ask a question, and now their answer might implicate or point a finger at doctor number 2 or doctor number 3. I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a great day.